Okay. Good afternoon, everyone. I'm Dr. Alvin Marcelo from the UPM Standards and Interoperability Lab. I'm happy. Dr. KM, this is a series that we started more than a year ago, and we're reviving it. You're the first revival session. And recently, I've been receiving a lot of doctors consulting me about the code that they've written using artificial intelligence. So I said maybe rather than just cover the topic of vibe coding, maybe we can talk about it from a high level perspective first and then drill down to the specifics of what they're doing. But before that, I'm happy to welcome everyone to this UPMC Lab series. We hope to do this at least twice a month, and this is our first time reviving it from uh, about a year and a half ago. Today we have Dr. Christine May Magtubo. I have the honor of being her professor way back in the early, never mind the date. She was my student in Introduction to Patient Care, which is a 3-semester course, no? Tagal nun. I'm happy to see all of my students there grow and be experts in their respective fields. In Introduction to Patient Care, she's part of the Intermed program of the UP College of Medicine, and it allows you to learn more about the art of medicine rather than the science of medicine. I'll ask Dr. KM to introduce herself also when she starts her presentation. Dr. KM, do you want to share your slides?
Yes, I can share my slides. Hold on.
Okay, I'll stop sharing now and then I'll turn off my video and then you can start sharing.
Yeah, so apologies that my video isn't showing. I think this is a hardware problem. I need
I
a
can see your slides. It's in slideshow. And hello, Dr. Billy. Good to see you here. Later on,
hello.
I'll ask you to say something, Dr. Billy. Dr.
Yeah.
KM, the floor is yours.
Hi. Good afternoon to everybody. I would like to assure everyone that I am a real person. Although the video isn't showing up, it's a hardware problem on my part, and I do look like the picture on the screen. My name is KM. I am an MD. I was part of the National Telehealth Center for a long time, working on the RX Box project. After that, I did entrepreneurship, working on biomedical devices. I did a short-term fellowship in Oxford on computer engineering, biomedical engineering. And then I pivoted into impact investing, specifically in the medtech and biotech streams. So as part of my work in bringing funding, capital, and policy closer to health innovators, I became an advisor for the Philippine Council for Health Research and Development's Intellectual Property and Technology Management Technical Advisory Group. So I think that's the hat that I'm bringing on today. We're not talking about the grant funding stuff that's available for health innovators, but hopefully this is still useful for everyone. So we're not going to be covering everything, but hopefully stuff that's useful for you guys. So just the 9-point talk proper agenda. Hopefully we go through it very fast so we can have time for questions. So the first thing is, why do we even have to consider intellectual property? Right? So as health tech innovators, as even casual coders, we're all creating intellectual property. Every commit, every device tweak, every data set that you manipulate in some way or form is already creating intellectual property. So there are two main types when it comes to healthcare innovation. There's the software, right? This is governed primarily by copyright. And the good thing is it's automatic. So the moment you write code, that is automatically protected by copyright. For devices, it's a little bit more complicated because you need to file it, you need to disclose it, and you need to file it. This is governed primarily by patents and utility models. What is the role of IP in healthcare innovation? Why do we even need to file copyrights or file patents? IP is the bridge between your idea and the people you want to reach through your idea or through your invention. It's the gateway to impact. When you have an invention that is not copyrighted or not protected by IP, the tendency is for it to stay in the bench or to stay in your lab. So it's very important um, to protect your assets, protect your intellectual property so that you can get access to tech transfer, licensing, commercialization, and so that it creates the impact that you imagined it would, in the real world. So it's not just paperwork, it's really the bridge, the gateway to the impact that you want to create. Why do you need to register? As I said, software, it's automatic. The moment you create it, it's accrued to you. So why do you even need to register? The baseline here is it creates evidentiary support, right? So it's a dated official record of who created what first, right? That's evidence of ownership and priority. When you have that evidence, that enables your copyright, your product, your code, your service, to become an asset that you can then leverage for funding. You can leverage for to be packaged into other things for licensing. And it also becomes a barrier for someone else, to stop someone else from patenting your own work and then blocking you from using it. So copyright doesn't technically need registration to exist, but registering it still strengthens your capacity to use it for impact, your parang leeway and runway to use that so that it can create the impact that you want it to create. So very important pa rin to register your IP. Now, the IP landscape in the Philippines, very, very fast, is governed by, the IP code, RA 8293. It's a very thick document. This is the code, the law that governs everything. Patents, copyrights, trademarks, utility models. Syempre, we have the IPOPHIL. IPOPHIL is the filing office. More than the filing office, actually, in recent years, they've also released a lot of circulars, memoranda, issuances governing how the IP landscape or how the IP practice in the Philippines is going to move forward, especially with the advent of AI, vibe coding, etc. So for the University of the Philippines in particular, you have your TTPTO, you have your Tech Transfer Office / your I don't know what it's called now na. But for particularly for UP affiliated teams, this is your entry point or your gateway, right? So they are your friends, they're not your enemies. If you have a question about intellectual property around your innovation, around your code, my suggestion is to go first to that office and then ask for guidance. So ownership questions, licensing terms, disclosures, they are your go-to. So this is the landscape in which you operate. So you have the law, you have the filing office, the national kind of standard setting body, and then you have your own office within the university that can guide you through this process. I have this before. Okay, great. Okay, so let's drill down to the different things, right? So software copyright in the Philippines, how is software protected? So as I said, it's automatic under the law. As long as when you write it, it's already accrued to you, because computer programs are protected as literary works. So the same as books. So the moment you write it, it's yours already. As I said also earlier, registration still helps. Where do you register? You register at IPOPHIL or the National Library, because that creates the evidentiary record. What copyright does not cover is the underlying idea, algorithm, or functionality in the code or in the program that you wrote. So someone can legally build the same feature from scratch. That's the thing. So your actual code, that's protected. But someone can have the same idea as you did, employ the same algorithm, and then express the code differently, and that would still be copyrightable. That's very important to consider when you're trying to file. That's when you build in barriers in your code to make sure that it doesn't get copied by other teams. So one of the questions that Doc Eloy posed when we were designing this short talk is, if you use someone else's software to write your data, can you copyright what you wrote? is your data yours? So that's quite complicated. But the short answer is yes, because most software vendors do not naman own your data, right? The long answer is usually because some do. And as health innovators, or like as casual users, I would say all of us na mostly no, in the world or even in medical practice are casual users of AI. We don't really drill down into the terms of use or their end user license agreements. The bottom line here is you have to check the platform's terms of service. So you might not be accruing or giving them automatic ownership over the data you inputted, but you give them a license to host and process it in their own ways. So that could be problematic if you're trying to copyright or you're trying to patent. Raw facts or raw data that you entered isn't copyrightable anyway. However, your selection arrangement or how you compile the data, the structure, the categories, the analysis that's embedded within that platform could be copyrightable as a compilation work. So then, you have to see what the platform's terms of use or terms of service allows you to copyright. The bottom line here is read the end user license agreements, read the terms of service, know what rights you're granting to the platform, right? And then if you're still unsure, export it to an open format so that you're never locked into that platform. So I hope that's useful and understandable. Next, so building on the cloud. This was also a question. Like, if you build on something like AWS, is that copyrightable or patentable? So as I said, copyright, yes, automatically that's copyrightable pa rin. The particularly for Amazon, the agreement is explicit na it has no rights to your content beyond what's needed to operate the service. So if you use AWS, good news for you. You keep full ownership. However, if you use their other SDKs, and there are other dependencies within the AWS ecosystem, those carry their own license terms. So again, the bottom line here is read what you're using, read the terms of service, read the end user license agreements, because you may need to comply with attribution requirements. So you may need to disclose that you used AWS in your copyright application. For the patent, it will still depend on whether you have an inventive step. That is what separates a patent from a utility model. So although these cover devices in the United States, you can patent some code already. In the Philippines, hindi pa. We don't allow patents for codes, only copyright. So utility models don't need an inventive step, but they still need the cloud coded thing to be new and industrially applicable. So the bottom line is, wherever you build it, it's irrelevant. For a patent, you need an inventive step. For the copyrights, you need to read whatever is you're allowing the platform to have, and whatever the platform is also requiring you to share with them. So, okay, that's for cloud computing. So the other protections that you can provide your invention is, as I said, a patent. This one requires a novel inventive step. You need to file it. This is not automatic. And someone needs to study your filing, read your filing to make sure that it is novel and it is non-obvious to a skilled practitioner, to a skilled person. A utility model drops the inventive step. However, it has to be new and also industrially applicable. This is why most healthcare innovators prefer the utility model. It's faster, it's cheaper, and more realistic. Trade secrets are the perfect, I think, vehicle for internal algorithms and configurations that you don't want to disclose. You don't file this because it's a secret. And then the protection only lasts as long as it's secret. So the moment that you talk to it, to your partner or to your friends, it's not protected anymore. Or the moment that the lead coder who holds the secret resigns, then it's not protected anymore. Trademark is usually for your product names, platforms, logos. This is also filed with IPOFIL. This protects just the brand, not the underlying technology. So these are your other options for things that you invent. So the meat of the talk today is AI in health, IP, specifically for doctors like me who vibe code a lot. So, okay, the question is, can software be copyrighted? So this was quite interesting for me to research as well. The short answer is it depends on how much of it is yours, and this is now like a settled law. It's not a gray area. So there is already precedent from the U.S. Supreme Court locking in the human authorship requirement. So the code that an AI produces purely from a prompt with no meaningful, so this is the wording that has, that's very important. Meaningful human creative input is not, I repeat, not copyrightable. So a prompt alone does not grant you authorship over that code, right? In the Philippines, as you can see, actually nauna pa tayo, no? Nauna pa tayo maglabas ng memorandum circular February 2026. In the Philippines, under IPOPHIL's revised copyright registration rules, they now require you to disambiguate, to disclose which parts of your code were generated through AI when you register for copyright, because only human authored parts get protected. The logic behind this, when I asked IPOPHIL earlier last week, yeah, late last week, was the AI cannot own code because the AI is not a natural person or an organization. So only the portions that were human authored can get copyright protection, because only humans can get intellectual property registration and protection. So the bottom line is, what you own are your edits, your refactor, architecture, etc., the parts that show human judgment, human creativity, right? So the important thing for you to do if you vibe code a lot is to document the prompts that you used, the edits that you made. And if the copyright is on shaky ground, like you already built something and there's quite a lot of AI generated portions, maybe consider not copywriting it and keeping it a trade secret, because that is always an option anyway, right? So this is already a memorandum circular. There's precedent in the international space as well. So hopefully this is useful for everybody. So in the Philippines also, AI inventions, so this is also useful. AI inventions are patentable as of July 2025. Under the new IPOPHIL examination guidelines for AI-related inventions. So what are the three things that we need to remember? Standard patentability rules still apply, so you still need to meet novelty, inventive step, industrial applicability, the same as any other invention. You can't patent a bare algorithm. You need the AI invention has to be a technical solution. That is a requirement. You can patent a system that applies an algorithm to solve a technical problem, but you can't patent the algorithm itself. Does that make sense? I think yes. Okay. And then this one also. This one also is their bottom line is human inventors only. So only a human or a juridical person, that was the term I was looking for, juridical person can be named as inventor of applicant. So even though Claude helped you a lot, you cannot name Claude as a co-inventor. So that is when you need to disclose, disambiguate which parts were authored by you, which parts were authored by AI, and then the authorship will belong to the human who guided the AI related invention. And then for patents, they are patentable if they meet novelty, the inventive step, and industrial applicability, and they are used as a technical solution to a problem. Okay, so quite a mouthful, but this is very important. So on training and third-party data models, okay. The fine-tuning on facility or patient data, if you fine-tune a model on facility data, the IP and privacy status of that data carries over. So let's say you use PGH data, right? Philippine General Hospital data. If you don't have rights to use that data and you use that data illegally, that creates a liability problem for you. however good or generous or useful your output is. So if you use other people's data, make sure that you have the rights to use that data and that you are following the privacy rules set for that data set. Foundation models, they have their own terms, ito na naman. So that's why it's very, very important to read the terms of service and the licenses. So you have to check, especially if you have an eye towards commercializing or selling your invention. You have to check whether commercial use of the outputs you generated under these models are allowed and what happens to the data you feed in, right? So you have to check, does the ownership transfer to you? Does it not? Do you have to work some sort of legal arrangement with these models before you commercialize? And then know what you are opting in at the start. Know your default opt-ins. So when you sign on to Claude, Gemini, GPT, DeepSeek, whatever, there are several options that you opt into automatically. So a lot of these are used in order to train future models for that AI, unless you opt out. So if you say feed it hospital data, right, that might be a breach of the hospital data's privacy because you're giving a third party access to private patient data. So you have to check all of this before you use any facility or patient-derived content into your prompts, into your AI modeling tools. So make sure, because the bottom line here is the privacy settings, the privacy policies around that data carry over whatever platform you use. So the real risk actually in AI and coding and anything in healthcare innovation is not just intellectual property, right? Who gets to own what, but it's actually patient data and patient safety. So, for example, Cursor, Replit, etc., they don't sign business associate agreements or agreements to protect patient data that enters their systems, right? So when you use any of these, that's a compliance problem on the data privacy end. It's not an intellectual property problem anymore. In our environment, in our ecosystem, the PH Data Privacy Act still applies, right? So under the law and under the advisory, NPC advisory in 2024 that governs the AI lifecycle, if you are the developer, you're the personal information controller of that data. You are the accountable person, regardless of whether ChatGPT or Claude wrote the code for you. You are accountable for what happens to that data. You're kind of the DPO, the data privacy officer for that data. And related to that, the current medical board guidance is still clear, although it's outdated. It's still based on the Medical Act of 1959, which states that the physician is fully responsible for the records and the clinical decision, no matter how much AI contributes. This has not been tested in the courts in the Philippines, but in the United States, it has been. And when there are many, you can Google these na lang, but there are many instances where the AI has made errors, and the physicians who implemented the AI were held responsible. So in our practice, the physician still remains fully responsible for the record and for the clinical decision, no matter how much the AI contributes. And then AI-generated codes often default to insecure codes because you don't really see how they're building it, right? So more often than not, there's missing encryption, there's missing audit logs, unless you explicitly prompt the AI for healthcare grade security, it's insecure, basically. So the real risk with using AI to generate healthcare tools or healthcare inventions, I think, isn't really just about the intellectual property, but about ensuring the safety of our patient data and eventually the safety of our patients. So what are some guardrails that we can implement as physician developers or as healthcare health tech developers? If you can avoid it, don't paste real patient data into a prompt. De-identify your test data as much as you can, always. Uh, That was a thumbs down for Doc Elway. Use synthetic or de-identified test data. Check your AI tools, all the licenses, right? Human review anything before anything goes live. This goes not just for
I'll try to get KM back. Standby. Let's wait for Dr. KM. She called me already. Nagkaroon ng internet in the Philippines blues. So I'm seeing a lot of good questions, no? Of course, software is copyright according to Dr. KM. Software written by AI cannot be copyrighted because AI is a machine. If you want to copyright something that you wrote together with AI, you have to qualify which parts of the software were written by you and which were written by AI. Pagbalik ni Dr. KM, let's talk about open source, Brian. I'm one of the advocates there. Um, James said, not fully knowledgeable on this sphere. For openly accessible hospital list, facility list information from the internet, if uploaded under AI platforms, can this also be a liability? Okay. For censored patient participant data, de-identified, can this be uploaded under AI platforms? Okay. Um, from Dr. Thomas, as a clinician developer, can we claim the code is ours after minor tweaks or edits than that of AI? My understanding, Dr. Thomas, is you can claim what you wrote, but you cannot claim what the AI wrote. So I haven't tested this yet. So maybe we can ask Dr. KM when she gets back. How strict is IPO Philippines when it comes to enforcing their February 2026 circular, where they said you need to disambiguate, which to my interpretation is show me the source code and then show me which one you wrote as Thomas and which one was written by Claude. Mm. I think let's give more time to Dr. KM. Dr. KM, when you're back,
Okay,
just
I'm back na.
okay.
Sorry.
It's
I
okay.
lost the
Share.
power.
They stayed because they have a lot of questions. So finish
Sorry,
your
sorry,
slides. And
sorry. Thank you
it's
so
okay.
much for
Sure, sure.
staying. So I think we were already, yeah. So yeah, so guardrails for physician developers. So human review, I think that was where we settled last before anything goes live. And then document AI involvement. As we said, there's already ruling around this now um you can only really patent or copyright human involved, the things that you generated that's human, and then build in what AI won't do at default. Build in your security guardrails, build in your encryptions, authentications, and audit logs, or ask for them explicitly when you prompt. So I have some stuff on open source licensing, but I want to move on to ethics, just being mindful of the time in IP and healthcare innovation. So first things first, we already discussed this a little bit, IP and equity. So patents raise that question around If you patent it, then it's kind of exclusive already. It's not accessible to everyone. But patents and licenses are how we recoup the costs of research and development. So that incentive for inventors is very necessary, very real. However, we recognize that the same exclusivity can syempre slow adoption, slow the impact that we want to make. So to balance both, there are many, many different ways, and this is where your technology transfer office, business development office can help you. My advice is to have a very clear direction on how you want your invention to be used, how you want your invention um, to be commercialized, so that you can talk to them about open sourcing components that don't need to be competitive. They don't need to be a competitive barrier. Um, Humanitarian licensing, there's also such a thing for public health use cases, differential pricing, etc. So you do have options if you're worried about exclusivity due to IP uh, IP constraints. So this one, I'm going to keep harping on patient data privacy and consent. Data is a byproduct, not a benefit to claim. So the tools that we generate, they're part of clinical care, right? So you always have to ask who owns it and what were patients actually told when the data was being collected. So you have to abide by right now the Data Privacy Act and also the privacy policies in your institution. Consent and purposeful limitation still applies, right? So the minimum necessary use principle sits on top of whatever IP rights you hold in the software, and the PH Data Privacy Act still holds. And you have to understand as an innovator that IP rights and data rights are separate. So you can own the copyright to your code and still have zero rights to reuse the patient data that passes through it for another purpose. You still need to gain the rights to that data. So IP rights, data rights, they're separate. And IP rights are covered by the IP law. The data rights are covered by the data privacy law also. So conflicts of interest. Ito interesting, no? As clinician inventors. Um, because we treat patients and also invent things from our learnings from those patients. The advice that is often given is to disclose your role, that you're also inventing and that you're also gathering data, etc., for your invention. Um, and if you're treating patients with or recommending a tool you've built that you stand to profit from, it's worth it to disclose that or in conflict openly. Guarding against your IP interests and shaping the tool's design over what's actually best for the patient. I don't think that's usually a problem in the Philippines, but you have to internally check if they don't, right? So most of us are motivated. I think at least most of the people that I've met who are inventing were motivated by delivering efficient care for our patients, being the best clinicians for our patients. But conflict of interest always is should be at the forefront of our minds as well as clinician inventors. Ito important because there are institutional disclosure requirements. So you have to look at the University of the Philippines and UP Manila's IP policy, when you should disclose that you have an invention, when you should disclose that you're using patient data, etc., and abide by those rules just to make sure that everything that you are doing is above board. Okay, and then some guidelines, you can just read through this. This is general alma ata stuff. So protect human autonomy, promote self well-being, etc. Transparency and explainability, inclusiveness and equity. In the Philippines, specifically, the Data Privacy Act and the recent NPC advisory on AI still applies. The use of AI for transparency, legitimate purpose, and proportionality across the entire AI life cycle, from training to deployment. And then again, you are accountable for the AI outcomes as the clinician inventor, even when a third party AI provider did most of the heavy lifting, did most of the work. You are accountable for the outcomes for that particular tool. Okay, so I think this is the final slide. So practical workflow, just a few suggestions for everyone. But this is actually for Scilab, Doc. So actually for everyone doing no. So before you build, check prior art or existing patents. Maybe someone has already built that. Pick a license that you want to, pick a vehicle that you want to employ upfront. Put IP ownership in the contract, who owns the customizations, etc. While you're building, document your decisions, algorithms, etc. Very, very important. And then keep the facility provided data ownership separate from your code, because those are governed by different data rights. And then after you deploy, state the licensing terms and revisit the engagement if the scope changes for you. Okay, so common pitfalls for clinician inventors. I think unclear ownership, we already discussed with clients, or specifically with the data, or if you're working within a hospital and you're using resources from that hospital, who's going to own the IP. So that's a common pitfall. The answer there is an agreement, an inventor agreement. Ambiguous or missing licenses, premature public disclosure. So this one also, if you're a researcher, if you posted or demoed a device or a software, etc., publicly before filing it, that can kill your patent eligibility. Or publishing it in a research paper. And then treating AI written code or patient data in a prompt as no big deal. We already covered this. Without human authorship, it may not even be copyrightable. So it is a big deal. So before your next repo, these are just a repeat of that. So yeah, I think that's it. Thank you very much for bearing with the technical
Thank you.
difficulties.
Thank you,
And I
KM.
hope
KM,
that was useful.
very, very useful. Very useful. I'm so proud of you. I'm so happy because everything that I need, you were able to answer. Kaya maybe you can also type your contact information,
Oh,
because some
sure.
of them
Yes.
might want to contact you after this call. I have some questions for my. Oh, yeah, I can see you now. I think the
Yes.
downtime fix the camera.
Yes.
Um,
I'm in my laptop now. That's why.
Okay, so I will not talk about my questions first. Let's talk about James Andrews and Agustin's question first. For openly accessible hospital lists or facility lists, information from the internet, for example, DOH websites or annual reports, can we upload them to AI? Or is this also a liability? So these are public documents.
Uh, so the general rule is whatever the data privacy policies around that document
Mhm.
carries over. So if they're publicly accessible, I think the liability is less, right?
Mhm.
Because the liability will be primarily, so if it's a DOH facility list, that the liability will primarily be with the DOH for publishing that list, right? So
Because they were the first ones to publish it
yes,
anyway.
because they were the first ones to publish it anyway. I think the safe thing to do is to always document where you got your data,
Mhm.
and to also investigate the data privacy policies around that data.
Mhm.
Because I'm gonna be very honest also, the DOH with publishing all of these data, they're not very how do we say this? They're not
Therefore,
careful, yes, as
uh,
careful sometimes. As
okay.
careful sometimes. No,
Yes.
so
Mm.
I think they publish it in the hopes of informing the public. But now that we were in the age where we can get that data and do something about it, create
Mm.
something with it, they don't have the policies around that yet, right? So
Mm.
for now, it's kind of a gray area, but
Mm.
the general ruling is whatever the data policies that were attached when that was published, when that data
Mm.
was created, how that was created,
Mm.
how it was meant to be used, then
Mm.
that carries over. So my tip would just be to document where you got it, how
Okay.
you got it, right? And then investigate if there are any other data policies that are attached to that particular data.
And so because I did not know that I can invite you to this talk
Oh,
before, what I did was I asked permission from DOH if I can upload it to Claude. And then I made sure that I removed all the names in the, because
right.
they have
Yes.
names. They have names
Yes.
of people.
Yes.
But
And
the Data
facility.
Privacy Act, the Data Privacy Access, this is not, what do you call this? The data privacy is not is not imposed on government officials, especially if it is their name and their designation as government officials.
Mm,
So because it's also for the protection of the public to
yeah.
see whether these documents are actually published or
Yes.
printed by people who are official. Okay.
Yes.
Next question. For censored patient or participant data de-identified, can this be uploaded? So tinanggal mo na yung identifier. Kunyari, example, X-ray result. I remove the name and the identifiers, age, sex. Can this be uploaded under AI platforms? Over.
Uh, as long as they are already, so the question would be they're de-identified na, no? And there, can you upload them? Again, the the data privacy um question here is carries over, eh, who owns that de-identified data?
Correct.
Are they
Correct.
allowing you to use that data
Yes.
to create something in Claude or in AI?
Yes. Yes.
So that's parang the de-identification, that's a step that you need to do anyway in order to
Yes.
protect patient safety, right? And to preserve the confidentiality of that data. But whether or not you can upload it, it would be sino ba yung may-ari nung data na yun? Who collected that? What was the purpose for collecting it?
Okay. Always ask permission, ha? Guys.
Yes, yes,
It's not, just imagine if it was your X-ray result and then somebody else removed your data and uploaded it without asking you permission. Personally, I will be offended. So if you don't want to be offended, don't offend others as well. So here, Jong, you raise your hand. Go ahead.
Sige, thank you so much. Hi KM, very very informative ano no. Talk. Ang tanong ko lang is for example, kunyari like for us researchers no. So we get all the permissions properly, then we develop AI and then we publish them without ever intending to actually exploit them commercially for ourselves, right? Pero we published it and then we cannot prevent others from exploiting it commercially. So in other words, kunyari, may gumamit na iba dun sa mga na-publish namin and they started commercializing it. Tapos nakita ng mga data owners, no? So kunyari, vulnerable populations yung data owners. May claim ba sila against us who did the original research on AI or will they make the claim against the ones who are actually commercializing the AI that we developed? So parang may layer na ano. Does that ano? I haven't seen any any examples of this, but certainly we researchers we publish no so that others can do what they need to do, and you can prevent like corporations or businesses to exploit those those intellectual property that we never protected to begin with. So may onus ba sa amin to actually protect that intellectual property in case someone else decide, kasi pag pinublish na namin yan wala na kaming control, diba? So this is why.
right. Yeah. So I think it's not a question of intellectual property, but really a question of data privacy,
Oh, malamang.
specifically for marginalized populations. So ang ruling ng NCIP there is always free informed FPIC, diba? Free.
Pero tapos na kami dyan kasi kami
Okay.
yung researchers. Tapos
Yes.
na yan.
So
it's
with that, if
the
you
next
followed,
round.
if you followed the FPIC, then you guys cannot be held responsible
Okay,
for that because you already followed that layer, no? So in terms of yung namang the person who developed something and commercialized it, could then the marginalized population
make a claim.
hold them accountable? No
Correct.
more, kasi they developed on top of publicly publicly available research, right?
Mhm.
And they developed on top of that. So we have things called background IP and foreground
Mhm.
IP. So background intellectual property is kind of the ano ba to? Base layer of
Mhm.
the
Pero remember, we never filed IP kasi
That's okay. That's
we
okay.
never intended to file
That's
IP.
okay. Yeah, that's okay. Kasi remember also pagka code yan, software, that's automatically, that's a literary work, that's automatically yours,
Ah,
no? So even if
correct.
it's not protected, that's automatically yours. That only means na they
Mm.
can exploit it without talking to you or without paying you, no? So that's
True.
automatically yours. They exploited it, they built on top of it, so that's their foreground IP. So their foreground
Oo.
IP, whether or not they choose to protect that, that is their responsibility already.
Correct. No,
Yes.
ang question ko is, pwede bang mag-claim yung data owners, which are the marginalized populations, dun sa commercial activity nung nag-exploit nung AI that was developed out of the background, the baseline
My
AI?
opinion is they cannot anymore. They
Mm.
cannot
So,
anymore.
I mean, ang onus dyan, so if you say that, ang onus would be for us, researchers, to
Yes.
actually protect the IP
Yes.
for the marginalized communities
Yes.
para hindi na ma-exploit ng iba.
Yes. That
Oo,
would be
for their
yes.
own.
That would be
Okay. Kaya lang,
the prudent thing to do. The
pero
prudent
madugo yan kasi, IP of course is very difficult sometimes.
Yes. Also,
And
IP
publication is a lot easier. So,
that's true.
oo.
Publication is a lot easier than commercialization. Yes, that's true. Yes.
Okay.
Sige.
Thank you,
Thank
John.
you.
Come back later.
po.
From Darwin Ranada, for EMRs or online interfaces, siguro mga API, no? Developed by employees of a hospital for a hospital. Who owns the copyright? Is it the employee or the hospital? And if these online interfaces are adopted by other institutions, what proper registration to IPOphil needs to be done to maintain ownership of that interface? That's
Nako, okay. Okay, so that will depend on the IP policy of the hospital, right? So many hospitals now, they have their own intellectual property policy. So for example lang in UP, I think it's still 60-40, no? 60 in favor of the inventor and then 40% ownership in favor of for the university. So if that's 60-40, that means you own 60% of any royalties that will come out of that license.
Okay.
As the inventor. And
Okay.
then if you decide to commercialize it, which means you license it nga, you allow it to be used by other hospitals or other
Yes.
universities, that will have to go through the hospital or the university's tech transfer office, technology transfer office, or business development office. And those will be agreements that you will decide upon, because you can license things for free, right? In exchange for right to see whatever they developed on top of it, in exchange for rights to see their data, etc. So that will really depend on the policy of your hospital. If there is no policy,
Yes.
the default is what is in the law.
Law.
So what is in the law is that you own the copyright that you created, and the institution has no claim over it if they don't have a policy stating
Yeah.
that whatever you create under their roof is they have a part in.
So look for a policy. If there is no policy, RA 8293 will prevail.
Yes.
Okay. From Brian, comment lang naman, there are copyleft software, open source, no? Open source is very, like we were the international open source network,
Yes.
diba? In 2007 to 2010, we were promoting open source.
Yes.
And now open source AI models, open source weights, and then open source supply chain poisoning, stuff like that are coming out because AI can easily access open source. And therefore, AI can learn from the open source software. So people are, a lot of innovations are happening because of open source, but also a lot of vulnerabilities are being detected. What is, ang laki ng question sa open source.
Yes.
What is your advice to developers who have not yet open sourced their software?
The decision whether or not you want to open source your software is I think philosophical, no? It really depends on what your leanings are. Kasi there are benefits, right, to open sourcing your software, open sourcing your code. There are also hindrances. So my advice is think about how you want your invention to be used, right? What is more important to you? Do you want to profit from that invention or that creation, or is it more important to you to seed more innovation
Yes.
without getting credit, in essence, no, without anything coming back to you? So that would be that would determine whether or not you want to open source your invention. I think it's more philosophical than medyo mahaba-haba ang
Yeah,
conversation.
we can have another session on that. Brian, go ahead. Sige. Open your mic.
Yeah, just wanted to add po. So given that a lot of AI coding tools like really enable people who aren't particularly familiar with the practice of software development, especially when with open source software licensed with the AGPL, as I mentioned earlier, it becomes a matter of legal obligation to actually open source the modified software. So even if you take like an existing project and then you use AI vibe coding tools to go to recontextualize the operation of that software, it definitely needs to be open source.
Yes. It also depends on for example, MIT or Apache, you can, modify seller code as closed source. You don't have any obligations to share changes back, right? But for GPL and AGPL, yeah, it's they must release their modified source too. So I guess it will also yung options mo will also depend on what you want, right? So if adoption matters more than reciprocity to you, then maybe you use MIT or Apache 2.0. If the improvements to the flowing back into the commons is more important to you, maybe AGPL, GPL is more for you.
So this is complex. I mean, I ask AI create this software for me, and then to write it, AI took a GPL code somewhere in GitHub, and then copy pasted it into the code that I asked it to write, and then added some more. AI added some more, and then gave it to me. Hindi naman ako coder eh. So I look at the output. I'm happy.
Yes.
And then I go to IPO Phil. Maybe I add my name.
Yes.
Generated by Alvin Marcelo.
Yes.
I cannot. I mean, I don't even know that
you have a legal obligation.
There was a GPL there.
Yes.
Because,
this is why
it's background. No, it's like AI followed my instructions, got the available code. It was AGPL, gave it to me, did not tell me, and now I'm trying to say, oh, I have this nice software. I'm going to conferences, announcing it to everyone, and then suddenly, apparently, I have compliance problems because it was AGPL in the first place.
This is why it's very important to read the terms of service. Kasi yun na nga eh. So for vibe coding, it's really difficult to see kung saan where it's pulling from, because it happens very fast, and if you don't open that little thingy tick box so that you can see what it's doing in the background, it's really difficult for you to catch these things. I think another session might be worthwhile for you guys to consider is teaching vibe coders how to prompt so that they can, so for example, you could include it in the prompt to avoid using AGPL or GPL, or avoid using these other stuff, no? If you're really ang gusto mo talaga is to commercialize or to go to conferences and register your invention, it might be worthwhile to also teach prompting for in the service of learning how the code is generated by the AI, right? So yun. So it might be something.
Another session.
Yes, another session.
So kasi
related.
kasi as you know, parang as the knowledge as AI becomes more ubiquitous, we will encounter problems like that. So so there has to be a way to kind of teach
Right.
people how to
Right.
do it.
Mm. So that's why we're interested, Silab. There cannot be any exchange if there are no interfaces. And then
Mhm.
if you don't know what are your licenses on both sides of that bridge, magkakagulo eh. That's why I wanted to have this first session so that we can understand, how can we have confident, secure exchange if we don't understand
Correct.
intellectual property. So we need to understand intellectual property. Thomas Reyes, he's a doctor, also a developer. Can we claim the code is our own after minor tweaks or edits over that given by AI? So kung nag-generate si AI, then dinagdagan ko. Second question, can we secure patents while maintaining it as open source so that we can protect our own products from monetization from other companies?
So first question, only the parts that were not AI generated can be copyrighted. So resolved na yan. Meron ng memorandum circular si IPOPHIL around it. So those parts lang that were can be copyrighted. So yes, you can apply for a copyright. You just need to disclose which ones were
Yours.
which ones were yours, which ones are not AI. And then the second question, Doc, was around patents and open source.
Patents, yeah. Yeah.
Okay, so there's actually an interesting case if you want to Google it. An interesting case in the U.S. Supreme Court around open source and patenting. It's not healthcare, it's fintech, but there's no the general consensus if it's open source, it's not patentable,
Mm.
right?
Mm.
So if
Yeah.
you open sourced it, it's not
Walang novelty. There's no
novel
novelty.
anymore. It's not novel
There's no
anymore.
novelty.
Because
Yes.
we open sourced it. So that's
Yes.
the general consensus. But
Mm.
because technology is improving and there are ways to kind of
Mm.
explore novelty and
Mm.
that
Right.
definition diba, of the inventive step, it's being
Yeah.
challenged. So worthwhile to look at how it's gonna pan out. But for now, in our environment, no. If you open source it, it's not patentable.
And one of the requirements of patent is there should be no prior art.
Yes.
So if you
that's
open
prior
source
art
it,
already.
yeah, if you open source it, even if you are the one who open sourced it, you violated the prior art yourself.
Yes,
So
correct.
it's like the Crocs, di ba? Yung Crocs, no,
Yeah.
they inadvertently released the design before they could get the protection. So, but it was their IP in the first place. So another question: since patents are territorial, what kind of patents should we consider for local/international distribution?
Ooh, what kind of patents? Sorry, ano yun, Prof? Ano yun, Doc, ulit?
Kasi territorial, di ba? I patented in the Philippines. It's not patented in the US.
Mm,
Correct?
yes.
But this IPO Phil has a network with other IPO agencies around the world, right? They check.
Yes.
Oh,
They
Alvin Marcelo submitted an RX box here. Do you have a similar patent over there? Because if you have, what happens? So erase, not RX box. Device.
Device is
invented a
software.
device. Yeah.
Yeah. So, I think, so okay, so IP is territorial. You are correct. Yes. There is a mechanism for IPOPHIL to help you if you want to patent abroad. So meron na silang internationalization schema that you can apply to. Actually, the DOST has grants for this. If you're very keen on internationalizing a patent or a technology, there's such a thing as a PCT, which grants you freedom to operate or a patent in like several territories. So multiple combinations that you can apply for.
Okay. Observation by Professor Jameson. In my practice, HIPAA in the US, they can detect even if you remove all patient identifier, it can still be detected. So
Oh,
you can
yeah.
be penalized. Okay.
Yeah.
All right.
We don't have that same mechanism yet.
Jong, go ahead, Jong. We have last 5 minutes and then let's give 1 minute for KM to wrap up. Go ahead,
Ayan.
Jong.
Sige, just quick question, no? So, in AI, we constantly remodel as data is added into the, nagre-remodel kami. So, the AI from this year may be a different mod AI for next year, but it's essentially performing the same function. Does that mean that we have to keep patenting? So every time we remodel, kasi bago na eh, we will keep kasi kailangan din yan, no? Transparency and account. You have to state all of those sa AI. So do we have to keep applying, for patents every time we remodel? And technically that could be, as soon as a new data set is around, you remodel and then your AI is new. So like every 6 months, every year, that's like, ang hirap
That's
nun.
Yeah. So I would advise against that. Also because baka hindi nyo ma-meet yung inventive step, no? That's very steep eh. How
Kaya
much
lang din,
how much
then
would
that-
remodeling contribute to originality and novelty?
De,
Diba?
pero may ano yan, there's an ethical question there where if the remodel, for example, the old model is no longer working and the remodel is better, you have to push the remodel.
Yes.
And do you have to wait for the patent to actually, be granted before you push the remodel?
Okay, so on the patent granting, even if it's not granted yet, if you filed pa lang, you're already protected. So that's fine. Kasi the granting, in my personal experience, can take a year, no? Even more, depending on the
File lang.
analyst. Yeah.
File
So
lang.
when you
File lang ng file.
Yung
Ganun.
file, ano ka na, finished ka na.
Okay.
And then when you file again for the same let's say for the same product, no, or the same service, what the IPOFIL does, their process is to consolidate your filings. So there is such a practice na consolidation. But the thing is, ito nga, so yung filing fee you have to pay. So that's the consequence of that. But they do consolidate, right? If hindi pa na-grant yung patent mo specifically, they do consolidate the filing, especially if they see that this is an update or this is for the same technology.
All right,
Okay,
thank you.
One last question from M and then KM wrap up. Wrap up ka na rin sa response mo.
Ay, sige.
Go ahead, M.
Hi, thank you, KM. Mag-share lang ako kasi so parang na-brought up yung patent, no? So, yun nga, so once you have a patent, in a way, protected ka anywhere kasi you can contest anyone who applies for a similar patent. So, kahit hindi mo na file sa ibang countries, you can still contest the novelty of that new patent based on your patent. So, in a way, protected ka. Tapos, yung mga yung mga innovative steps, no, parang yung sinabi ni Jong, you can actually add that as an addendum habang hindi pa nagagrant. So, mas madali yun kasi habang you have more evidence or more innovative features, you can add it as long as hindi pa nag-grant. Kasi mahirap na pag nag-grant, hanapin yung novelty.
Correct.
Ano yung, gaano kaiba yung additions mo over the existing one.
Correct.
Thank you.
Thanks po. Thank you. So I'm not going to respond because it's more of a comment, but thank you. Actually, si Sir M also helped us with our patent writing before, if you remember, Sir, with the RxBox. So yeah, so to wrap up, hopefully this was informative and useful for everyone. The bottom line is IP protection is the gateway to impact. And it's very important for you to consider whether you're building for fun or you're building for profit or for effectivity. So I hope this was useful. Thank you.
Thank you. Open your cameras, please. Open your cameras, KM, while you're opening. I'm so happy. Yeah, a lot of doctors in the call, vibe coding. So I hope that we were able to get a good input from KM. So smile, everyone. Smile, 1, 2. All right. Thank you, Dr. Billy, for joining us.
Thank you, everyone.
Bye. To the next one. Bye-bye.
Bye.
Thank you.
Thank you.